As a rights organization, how is Nigeria ranked in freedom of expression, human rights, and media freedom? Let's start from there.
Thank you very much. The ranking doesn't look so good. But apart from the rankings, Nigerians living in the country and those who engage with freedom of expression tools, even outside the country, can tell a better story of what the Nigerian government, the views of the Nigerian government on freedom of expression. And those actions are better seen in the various moves by the various arms of government, the executive. The president was at the forefront of the ban on Twitter, for instance. And the legislature itself has tried several times to pass legislation that, of course, infringes on freedom of expression, chief among which is some of the hate speech bill, and even the Cybercrimes Act have been used to clamp down on free speech. So the Twitter ban is just one in the series of actions by all arms of government to stifle freedom of expression, and that doesn't look so good. Recently, the Nigerian government also released some sort of code of ethics that will guide the use of internet and other facilities in Nigeria. This, again, is clearly unlawful and infringes of the rights of Nigerians, which is constitutionally guaranteed. Nigeria doesn't rank so good on freedom of expression matters, and that is not only limited to the aspect of expressing oneself, knowing fully well that constitutional guarantees on freedom of expression, even as articulated in Article 9 of the African Charter, is in two parts. One is the ability to speak, like the conversation we're having, and to use Twitter. And the second aspect is to receive information on both ends of the spectrum, whether to speak freely, your freedom of speech, and the right to access to information. Nigeria doesn't rank so good.
All right, let's look at that judgment now by the regional court. How enforceable are the judgment of the court on member countries?
Of course, they are clearly enforceable, but what we've seen is a trend of African countries not giving full effect to the decisions of the ECOWAS court. This is not for lack of the treaty of the protocol to create for mechanisms for enforcement of judgment, but a lack of willingness, you can call it political will, on the part of African leaders to obey the judgments of the ECOWAS court. And that itself makes a mockery of the ECOWAS treaty itself and the various protocols of the court that enables the court to adjudicate on human rights cases, either between member states or between the citizens of those states and the states themselves. So what we need to see is not really an enactment or a review of the protocol as it were, even though there are mechanisms that were put in place for enforcement of judgments. But for those African leaders to commit to obey the judgment of the ECOWAS court, as a regional court on human rights, that will really do good for democratic practice in Africa and enjoy the whole Africa, enjoy the full benefit of human rights as a way to assess the so much needed socioeconomic development.
When you look at some of the rulings of the court, nothing has been done in previous rulings. What is the importance of ECOWAS court's ruling? I mean, you go there all the time. Of what import is it?
One, the jurisprudence of the ECOWAS court is clear. The jurisdiction of the court is also clear. The court has jurisdiction over human rights cases, either between member states or among member states, so to speak, or even between the citizens of those states and the states themselves. And the African Charter on Human People's Rights is just one of those legal instruments that the court enforces. So the court is important as a regional court to give people the ability to ventilate their grievances, adjudicate in human rights cases, so to speak, enforcing and promoting the use of human rights mechanisms, ensuring that African countries and even the heads of states of those governments of those countries obey and promote human rights mechanisms in their different states. So the judgment of the court forms part of the jurisprudence of human rights mechanisms law in Africa and even internationally. And also the judgment of the court is binding on member states for them to obey. So whenever any judgment comes out of the ECOWAS court, it is good, it enriches the democratic practice, knowing fully well the importance of human rights to democracy and the role human rights play in socioeconomic development. But unfortunately, the lack of commitment to obeying the judgment of the ECOWAS court is not is not helping either the profile of the court or even the confidence of the people in the ability of the courts to do justice in cases of human rights.
Some persons are calling for damages to be paid by the Nigerian government to people whose businesses suffered greatly during the ban. First off, is it justified to be making this call? And second, is it even possible to begin to assess who was affected or not?
Of course, it's possible. It's not only possible, it is legal. The treaty, the ECOWAS treaty and the protocols of the court allows the court to give to do justice by way of reparations, and that is what we intend to do. Now that the court has done the needful by declining the ban as unlawful and inconsistent with the provisions of the African Charter on Human People's Rights, naturally, what should follow is will be others for reparation, which was not included in the initial suit. And the court has been quite magnanimous in also ordering the federal government, the Nigerian government, to bear the cost of the proceedings. And so, but what we need to do is to be able to give full vent to the grievances of the people. A cost follows events, it is said in law. And so in this case, the government has infringed on the right of the people. The court has said that the ban itself is unlawful. So naturally, those who have lost business, who have lost money, who have suffered in one way or another that can be quantified in pecuniary terms should be able to be compensated by the government. And that is why we are taking this step to go back to the court in this instance to identify individuals, as many people as can come forward with claims that will be vetted and verified by our lawyers to approach the court to award damages by way of compensation and in financial terms to those individuals. The Nigerian government cannot just carry out this unlawful act. 7 months, a total of 7 months, people could not access to it. And you would understand that particularly within the growing economy, the small and medium scale enterprises in Nigeria that rely so much on social media platforms like Twitter to advertise their business and to ensure that they carry out that trade suffered a lot within the 7-month period. And naturally, they should be compensated. And we believe that the court will agree with us in this regard. And we are really looking forward to the judgment of court, following up on the judgment delivered today.
We look forward to that as well. Thank you very much for speaking with us. Oluwadare Kolawole. Thank you.
Thank you.